This is a brief overview of real property law. And with that much in mind, we need to define what is real property and how is it different from personal property. Well, real property consists of land, of course, right? It also consists of buildings, fixtures, and I will define fixture in just a minute, but a fixture is an item of personal property that has become so affixed to the real property that it's actually part of the real property. It also includes rights in the lands of others. So we today will briefly touch on the law of easements. So as I said, land encompasses more than just the surface of the earth. It consists of soil, all things on nature affixed to the ground, grass, crops, trees. It also includes water under the ground, things embedded in the earth. In law school, we're taught this, that a piece of property includes air rights as well, so it includes not only the ground you're standing on, but in theory, down to the core of the earth and up to the sky. We're not going to talk about air rights today, but if you like law and you like real estate, consider taking real estate law in the fall. We'll talk about air rights, some really interesting things. The doctrine of implements, let me point this out, is that when a tenant has planted crops on leased property, the tenant has the right to harvest these crops even after the lease has ended. And we call that the doctrine of implements. So let's define that fixture. So an item of personal property may become so affixed to the real property that it's considered to be part of the real property. There's a three-pronged test to determine whether an item of personal property is real property, and here are the elements. Annexation. In other words, how affixed is it to the real property? Can you remove it without causing damage? Adaptation. Is that item of personal property specially adapted for that piece of real property? And then finally, intent of the annexor. What's your intent when you affix the personal property to the real property? So an item of personal property that often becomes real property is kitchen cabinets. Kitchen cabinets start out as personal property, but they are so annexed to the real property and they're specially adapted for that use, and the intent of the annexor, the person who affixes cabinets usually intends for them to go with the real property. I did want to point out this. There is this a notion of a trade fixture. And so in other words, equipment that a tenant attaches to a rented building and uses in a trade or business is usually considered to be a trade fixture, and ordinarily it is removable by the tenant. Years ago, I had a student in this class ask me at the break, this was a night class, and at the break he came up to me and he said, I need to ask you a question. My sister has a coffee shop in Virginia Beach, and she affixed a really nice awning out in front of the building, and now her lease is up and she wants to move and she wants to take the awning with her. And the landlord likes it so much, the landlord said, no, you can't have the awning. And he said, can she take the awning? And I said, yes, this would be considered to be a trade fixture. All right, you could have a present ownership in real property, or you could have what's termed a future interest in real property. So a present interest would entitle the owner to immediate possession and use right now. A future interest only entitles a person to an interest in that real property at some time in the future. So let me explain a little bit more. So the best possible present ownership interest in real property is called a fee simple. A fee simple absolute. It's a present ownership with an undivided rights. It is transferable during your life. It's transferable by your will. It passes to your heirs if the owner does not specifically devise it by a will. It can be subject to the rights of the owner's spouse. It can be attached to satisfied debts. That's the type of ownership that is the best possible present ownership of property. A fee simple interest could also be known as a fee simple defeasible. In other words, you have the present right to occupy the property or to own the property, but it may be lost. An example is Hull Springs Farms. This is a picture of Hull Springs Farms. It's beautiful, right? So this is a piece of property that was devised to Longwood University by an alum, And, and so long as this beautiful piece of property is used for educational purposes, it belongs to Longwood. If it ever ceases to be used for educational purposes, then it would, the interest would terminate. If you want to know more about Hull Springs Farm, take a look at the Longwood website. It's a beautiful, beautiful place. A future interest, and by this I wanted to mention a life estate. So most of you have probably heard of the term life estate. A life estate is measured by the life of a person. Normally it's the life tenant's life. So in other words, you own a piece of property and you can do anything with it you want during your lifetime, and then at your death, then the property goes to someone else. A life estate could be measured by someone else's life, and we call that type of a life estate pour autre vie. So with a life estate, the life tenant has the exclusive right to use the property for their lifetime. They could sell it. They could sell their life interest in that property. On death, the property either reverts back to the person who created it in the first place, that's the grantor, or that interest could go to another person known as the remainderman. Again, a life estate can be sold, it can be transferred to another person, it can be a reversion or a remainder. So here's an example of a remainder. To Al for life, and when Al dies, the properties go to Bob and Charlie. The remainder that Bob and Charlie hold may be sold. By the way, Al's life estate could be sold during his life too, but it would terminate at Al's death. We spend weeks and weeks in law school on future interests, but that's about all you're going to get today. Joint tenancy. Property may be held by more than one person, and we call that type of ownership a joint tenancy. There's several types of joint tenancies that are recognized under the law. A first type of joint tenancy is called a tenancy in common. It's a concurrent ownership, in other words, a non-exclusive right to possess a piece of real property. There's no right of survivorship, and I'll explain what that means in just a second. And although a joint tenant can sell his or her interest, he or she has no right to convey the entire property. All right, so I bought a piece of property that was held as tenants in common. So a man from Farmville owned part of it as a tenant in common, and a lady from Lexington, Virginia owned the other part of it. Now, they're tenants in common. It's an undivided interest in the whole property. So neither of them could do anything with this property by themselves. They had to have the other person do something with them. Well, the lady wanted to sell, the man did not. So I purchased the lady from Lexington her interest in that property. And then at that point, can I do anything with the property? And the answer is no, I still can't. So what I did was I brought something called a partition suit. So in other words, I petitioned the court. I said, all right, court, please do one of two things. Either draw a line down the middle, and I have my half, and the other man has his half, or put a price on it and let me buy the other person's property. Sometimes the court will actually ask that there be a public auction. In my instance, I ended up buying out the other person. For the same thing, I paid the lady from Lexington for her half. Again, there's no right of survivorship with tenancy in common. With a joint tenancy, there is a right of survivorship. There's equal and undivided interest in the real property. So let's say Al and Bob own a lot as joint tenants, and Al dies. What happens to Al's interest in the property? Well, then it would go to Bob. A joint tenant may sell his interest in the property, but the new tenant is not made a joint tenant with right of survivorship. The new tenant owns the property as a tenant in common. What I'll tell you is that frequently a joint tenancy is used as a substitute for a will. In part, it's because the surviving tenant has no liability for the debts of the deceased tenant. There's also a type of joint ownership with right of survivorship called a tenancy by the entirety. And a tenancy by the entirety may only be created with a husband and a wife. And so if the husband dies, the property automatically goes to the wife. If the wife dies, the property automatically goes to the husband. Now the advantage, one of the advantages of tenancy by the entirety is that only a joint creditor of both the husband and the wife may place a lien on this property. All right, so we're moving right along. An easement is the right of your right in the land of someone else. An easement gives the owner the right to use the land of another person for a limited purpose. It's a non-possessory interest. It has the potential to last in perpetuity or forever. So there are different types of easements. There's an easement in gross, that is if power lines are crossing your property, that's an easement in gross. Now, I just finished I was involved in a case where my property was subject to a claim for eminent domain. In other words, the government was going to take my property and they wanted an easement across my land to put in high-speed internet. At first, they offered me a very low price. They offered me $2,100 for the right to do that. So I look at an easement in gross like this, that they essentially have the use of that strip of property forever, and I have to pay taxes on it. I've not had good experiences with easements in gross, so I've had trees butchered and property torn up, and so I said no, I wouldn't let someone walk across my land for $2,100. So I valued that easement at approximately 10 times what they initially offered it to me for. So $21,000. $21,000 is what I figured it was worth if I took them to court. And so after many months of negotiations, I ended up settling this case for $15,000, which the way I arrived at that figure is that if I had to go to court and if I had to hire an attorney to represent me, they would take a third. So that's approximately $15,000. And so beware when the power company wants to, or the Commonwealth wants to have an easement across your property. It's worth a lot more, perhaps even 10 times what they offer you initially. So don't take the first offer. So an easement in gross is like a power line. There's another type of easement, and it involves 2 tracts of land, and that is an example would be a joint driveway. So easements can be established in several different ways. The most common way is by express grant. That is with the easement being recorded with the land record. So if you're going to buy a piece of property, you can check and see what entities or what people have easements over your property. An easement could also be created by necessity. So for instance, I have a piece of property out on Highway 15 in Buckingham County, and the only ingress or egress from that property is one driveway. What if I sell you the back 40 acres and I don't expressly give you an easement to reach the back 40 acres? There is no other way to get there. Do you have to buy a helicopter? The answer is no. The courts would probably establish an easement by necessity. And then finally, the last way to create an easement, and this differs from state to state, is by prescriptive use. So in other words, if you use a driveway or you use ingress or egress for the statutory period of time, this varies from state to state anywhere from 5 years to 20 years, then you get an easement by prescriptive use. All right, so contracts for the sale of land. So this should be somewhat of a review for you. A contract, of course, is a legally enforceable obligation. And you remember this. I know that if there's a breach of a contract, a real estate contract, one remedy that you have is specific performance. You can make the other person go through with the contract. The statute of frauds applies to contracts for the purchase of real property. And so your right in your contract must satisfy the statute of frauds and identify the parties, identify the property, and specify the purchase price. A deed. There's several different types of deeds that you could have. What you want, if you're buying property, is a general warranty deed. So with a general warranty deed, the grantor is essentially telling you, I have good title to this property, and I'm conveying good title to this property to you. Another type of a deed, and by the way, this is what you do not want, is a quitclaim deed. A quitclaim deed makes no warranties, makes no promises. In other words, I could sell you the High Bridge and give you a quitclaim deed, and the quitclaim deed would say, I'm conveying to you whatever interest I have in the high bridge, if any. By the way, I don't own the high bridge, so you wouldn't get anything. And then finally, there's another type of deed that under very limited circumstances, if you were my client, I would allow you to accept, and that's a special warranty deed. And a special warranty deed only warrants against defects arising since the grantor acquired the land. So maybe, if the grantor is your aunt, and she's held the land for 60 years, I may allow you to accept this type of a deed. But again, a general warranty deed is what you want. So executing a deed, we say signed, sealed, and delivered. In order to transfer title to real property, the deed must be signed and delivered. Actually, signing and delivering the deed is all that's needed to transfer title between parties. As a practical matter, though, virtually all deeds are recorded. A deed has to have all the signatures of all the grantors. In a deed, you will see a recitation of consideration. The actual amount that's paid for the property does not have to be included in the deed. In terms of recording a deed, there are 3 different types of recording statutes you could have. The first type of a recording statute, so let me explain this. There could be an unscrupulous seller who decides that he or she is going to try to sell the same piece of property twice. And for that reason, we have almost all deeds are recorded, and every state has their own type of a recording statute. So in North Carolina, the first to record wins. So let's say we have unscrupulous seller Al, and Al sells the farm at Clifton to Bob and gives Bob a deed. Al sells the same piece of property to Charlie and gives Charlie a deed. Well, the first person to go running down to the courthouse and records wins in North Carolina or in a state that has a pure race statute. In other words, the first buyer to record wins. Another type of a statute that you could have, and that's what we have in the Commonwealth of Virginia, is a notice statute. And I'll do an example in just a minute, but with a notice statute, recording statute, the last good faith purchaser to record their deed wins. In South Carolina, which is where I was originally a member of the bar, we had a race notice statute. In other words, the first good faith purchaser to record would win. So here's your hypothetical. On day 1, Oliver conveys a piece of property to Al, who is considered to be a bona fide purchaser. That is, he's bought the property without notice that it's been conveyed to anyone else. On day 2, Oliver conveys the same property to Bob, who is also a good faith purchaser. On day 3, Al records. On day 4, Bob records. And so the question is, who wins? Who owns the property? Well, it depends on what kind of a statute you have, recording statute, and what state you're in. So if you were in a pure race state like North Carolina, Al would win. If you were in a state that has a notice statute like Virginia, Bob wins. In other words, Bob was the last good faith purchaser who recorded, so he wins. If you are in a race notice statute state, such as South Carolina, then Al would win. Al is the first good faith purchaser to record, and so he would win. Now, if you want to sit for the real estate exam, you have to remember this. Anyway, let's look at title insurance. So title insurance is a great deal, by the way. Almost all lenders require title insurance. It's something that you should have. In Virginia, settlement agents are required to tell purchasers that title insurance is available. It's a great deal because the premium is reasonable, it's a one-time expense, and it covers defects that are in existence at the time of transfer of the property. So you say, well, I have an attorney, I don't need title insurance. The attorney is searching the title to my property. Well, while that may be true, there's also a statute of limitations for negligence or for malpractice, and that is 2 years. You only have 2 years to sue your attorney. The title insurance gives you much better protection. So here's my note to you. Title insurance is not transferable. There was a case in Virginia where the owners had title insurance, and that was a good thing. The individual owners decided to incorporate and transfer their real property to the corporation. After they did this, there was a defect in the title discovered. Are they still covered by the title insurance? And the answer is no. So be very careful and remember that title insurance is not transferable. Adverse possession. So I bet you didn't realize this. Perhaps you did, but a person who possesses real property for the requisite statutory period of time, and that's anywhere between 5 and 20 years depending on the state where you live, acquires title to that land. In Virginia, it's 15 years. In South Carolina, it was only 7, which somewhat worried me because I owned a piece of farmland that the surrounding owners really wanted, and I refused to sell it to them. And I also had no intention of going down to check out whether they were adversely possessing my property. 7 years goes by mighty fast. So here's the deal. If you claim someone else's property and your claim is open and notorious, in other words, it's of note, the way you could claim someone else's property is by taking your fence and putting it over their property. If it's hostile, that means without permission. If it's actual, you're actually possessing it and continuously possessing it. By the way, tacking is allowed, and I'll give you an example in a minute. And your possession of their property is exclusive, then it's yours after 15 years. Now, where we live at Shepherd's in Buckingham County, our farm abuts a piece of property that no one has paid taxes on, no one has claimed in probably 100 years. And so I'm claiming that property by putting a fence around it. Yes, will I have to pay taxes on it eventually? Yes, I will. I'm doing this without permission. There's no one to seek permission from, and it's actual, continuous, so tacking is allowed. So let's say I've done this for 10 years, and I convey my farm to my son, and he does it for another 5 years. Well, that property is his. So 10 plus 5 is 15. It's his. And you have to claim it exclusively. Mortgages and deeds of trust, very quickly. If you take real estate law, we'll talk about this for a day. But a mortgage, there's a difference between a mortgage and a deed of trust. We have deeds of trust in Virginia. A mortgage is a two-party instrument. It has to be in writing, and it vests a legal title conditionally in the lender, subject to the equity of the mortgagor. If you are behind in your payments, foreclosure is the procedure that's used. And to have a valid mortgage, there must be an underlying debt that is evidenced by a promissory note. In Virginia, we have a law that recognizes deeds of trust, and a deed of trust is a three-party instrument where you have the grantor as the debtor, the grantee is a trustee, and the beneficiary is the creditor. Legal title is actually vested in the trustees until the property is paid for. When allowed by statute, deeds of trust are preferable to, in the eyes of lenders, to a mortgage because if the debtor gets behind in payments, it's much faster to recover the property than a foreclosure proceeding. Leaseholds, again, very briefly on leaseholds. We'll spend a week if you take real estate law on leaseholds. There are a couple of different types of tenancies that you could have. A periodic tenancy is a tenancy from month to month, and that is the default if you don't specify the type of tenancy that you have. Rent, of course, is paid at the beginning of the term, and to terminate a periodic tenancy, a full term is required. So if you have a month-to-month tenancy, then you would give 30 days notice. You could also have a tenancy for a term or tenancy for years. So when we lease out our farm property, it's a tenancy for a term. A tenancy at will is where both parties can terminate at any time. So when I had my lake house for sale, I did not want it to sit empty during the winter, and I had a tenant who really wanted to live there. And so we entered into a tenancy at will, which could be terminated anytime the tenant wanted to move out. It could be terminated if I sold the property as well. And if you have a holdover tenant, that is somebody who stays after the leasehold is up, we call that a tenancy at sufferance. Subleases versus an assignment. So an assignment is where the tenant transfers his entire interest that's left in the leasehold to someone else. So let's say that you graduated in May, your lease goes to August, and you assign your lease to Bob. That is, you've assigned the entire remainder of the time to Bob. A sublease is where a tenant transfers less than the entire leasehold. And so let's say a sublease would be this. So your lease begins May 1st, and you're not going to be here this summer, so you sublease your apartment this summer to someone else, and when you come back in the fall, you resume paying the payments. With both an assignment and a sublease, I need to warn you that the tenant remains primarily liable on the lease unless released by a landlord. And the other thing for you to remember is that if you are a landlord, if the lease prohibits a sublease, but it doesn't prohibit an assignment, then you may assign your lease. The prohibition of an assignment by itself does not prohibit a sublease. So if you want to prohibit subleases and assignments, you need to use both of those terms. Landlord-tenant obligations, again, if you take real estate law, we'll talk about this for about a week, but maybe more when we talk, if you include commercial landlord-tenant law. So a landlord has an affirmative duty to keep the premises fit and habitable throughout the leasehold. The tenant has a duty to repair damage that the tenant causes. You have the duty to remove garbage, to pay utilities, and to not commit permissive or ameliorative waste. So permissive waste, what would that be? So let's say the toilet gets clogged up on the second floor bathroom, and you allow water to run down the steps and out the door and cause severe damage to the apartment. That you would be liable for. Ameliorative waste you may see as an improvement to the property. The landlord may not agree. A landlord in Farmville told me that he had some students rent his house, and they decided to make an improvement to the house, and they built a bar out of bricks and mortar in the living room of the house. The boys didn't understand why they couldn't get their deposit back because they had made improvements to the property. This, by the way, would be considered to be ameliorative waste, and you're liable for those damages. I did want to point out that a tenant with a disability may make reasonable modifications under the Federal Fair Housing Act. So if you need to put in a ramp, you would be allowed to do that. And that's it for real property. And you have a good rest of your day. Thank you.